Hello there, my name is Terry Gorry. I'm a solicitor and I just made this short video about the contract of employment in Ireland, in Irish employment law. It's a source of problems for employers and employees alike. This is created from the perspective, I suppose, of the employer, but it will be instructive to employees who may be watching this video also. So okay, let's take a look. Firstly, before granting a contract of employment in Ireland, there are three critical areas you need to look at and be careful about if you're an employer. One is advertising the position. Two is the interviewing of candidates. And three is conditions precedent. In other words, any job offers that you may make, that you are making that offer subject to or conditional upon the fulfillment of some condition or other. These are three critical areas for employers. Firstly, advertising the job. The wording of the ad is critical. It is very, very easy to discriminate against a certain cohort of people, and employment equality legislation is critically important here. So it's vital that the wording of the ad does not discriminate against any group of people in the 9 areas which allow for a claim to be brought to the Equality Tribunal, which can be very expensive. And coincidentally, this is a strange situation, but somebody who doesn't actually get the job, who was never your employee, can actually bring a case to the Equality Tribunal if they have gone through an interviewing process, weren't successful. They can still actually bring a case against you, even though, as I say, it's an unusual situation insofar as they are not your employee and never were your employee. Interviewing is a critical area also. Again, you're back to the question of discriminatory questions and discrimination. The Employment Equality Acts set out discrimination on 9 grounds. For example, marital status, membership of the travelling community, sex, religion, and so forth. Conditions precedent then. You should be making your job offer on certain conditions. For example, is the person healthy enough to do the job? You may well, make it a condition precedent that they pass a physical or a medical rather. They may need a clean driving license. They may need vetting, Garda vetting, depending if it's, a childcare job or teaching or whatever, or working in a school. You may need make your job conditional, or your job offers rather conditional on satisfactory references. The terms of employment then in a contract. Firstly, there are a number of implied terms in any contract of employment. For example, the right not to be discriminated against, the right to notice, the right to breaks and annual leave. These are terms that are implied by statute, in other words, laws that are on the statute books of the Irish state. There are also terms implied by custom and practice in some industries. And then there are terms that are implied by common law. For example, the employer's duty of care to the employee and the employee's duty of confidence and trust in the employer, and not to betray that trust. Then there are express terms of employment which will be spelled out in the contract. These can be oral or in writing, but they should actually be in writing for the sort of clarity and safety of both employer and employee. The Terms of Employment Information Acts of 1994 to 2001 set out that an employee must be given a statement within 2 months of appointment, certain information about the employment contract, and this is a statutory obligation on the employer, as well as the statutory obligation to provide certain information. It is advisable also for the employer to put in additional terms depending on the employment and the circumstances. For example, illness pay or sick pay, sick leave. Retirement age. Is there going to be a retirement age? The whole area of time off work. When somebody is out sick, for example, is it enough that they text in or ring in, or what is the arrangement? Will there be a probationary period? Will the employment have bullying and harassment procedures, and are these brought to the attention of the employee, likewise with grievance and disciplinary procedures. Fixed term contracts then are a specific type of contract. They end on a particular date, if you know the date at the outset, or on the occurrence of a specific event. For example, to cover, say, maternity leave, when you have a fair idea when somebody may be coming back to work, but you're not sure, and you need to make provision for somebody returning, for example, from maternity leave early. The Protection of Employees Fixed Term Work Act of 2003 protects these employees. That's employees on fixed term contracts. The renewal of fixed term contracts then can also be problematic. Fixed term contracts essentially cannot be renewed indefinitely, or a contract of indefinite duration may arise by operation of law. Fixed term workers then are entitled to be treated no less favourably than their permanent counterparts. The termination of employment contracts then is a very, very thorny issue for obviously both employers and employees alike. It can go pear-shaped, quite frankly, for employers. There are two crucial points to remember about terminating a contract. One, the notice period is set down by statute and or the contract. In other words, there are minimum notice periods set down in law, but your contract may allow for or provide a greater notice period. The reason for termination is important also, lest a claim for unfair dismissal arises. Changing a contract of employment is equally a difficult and problematic area for employers. It must be treated very carefully because an employer cannot simply change a contract of employment unilaterally, in other words, without the consent of the employee. For more free information about employment law in Ireland, you can visit my website, businessandlegal.ie, or you can call me on the number you see on the screen, or you can email me at terry@businessandlegal.ie. Thanks for taking the time to watch.